Hello and welcome to today's tutorial on rejection of non-complying demands under demand guarantee subject to URDG758. And we will also cover related issues when a guarantee is not subject to any rules and under a standby letter of credit governed by ISP98, along with a detailed case study to illustrate these points. In a typical demand guarantee, the guarantee is drafted on the assumption that any demand made by the beneficiary will be complying and that the guarantor will honor that demand by payment. However, URDG 758 Article 24 provides a specific procedure for rejection of the demand. The concept is somewhat similar to UCP 600 Article 16. But there are notable differences between these two sets of rules. If a guarantor fails to follow the concept of rejection procedure, it is precluded from rejecting the presentation, which means the guarantor might be forced to pay even against a non-complying presentation, leaving the applicant or instructing party with ground to refuse indemnification and potentially preventing the guarantor from making subsequent demand under a counter guarantee. According to ISTGP L172-176, further guidelines is provided on how URDG 758 should operate. When a guarantor determines that a demand under the guarantee is not complying, URDG subarticle 20A gives it a choice either to reject the demand outright or approach the instructing party or counter-guarantor in the case of counter-guarantee to seek a waiver of discrepancies. But it is critical to note that seeking such a waiver does not extend the 5-day banking period allowed under subarticle 20A. The rejection must be made via single notice sent to the presenter of the demand. And this notice, as required by subarticle 24D, must clearly state that the guarantor is rejecting the demand and must identify each discrepancy for which the demand is being rejected. This notice is typically given to the beneficiary, although it could be addressed to a third-party presenter. Furthermore, under subarticle 20E, the notice must be sent without delay and in any event no later than the close of 5th business day following the day of presentation. The phrase without delay is not precisely defined in URDG 758 and it has generated some debate. In some courts, without delay means the same day or the next banking day, although some other jurisdictions may allow a bit more time. Regardless, a guarantor must be extremely cautious not to breach this requirement because if it does, it will be precluded from rejecting the demand altogether under subarticle 24F. Essentially, the rejection notice must comply with 3 critical elements. It must clearly state that the presentation is rejected, and it should list every discrepancy on which the rejection is based. It should be given promptly and no later than the designated time limit. Failure on any of these elements means the guarantor loses the right to reject the demand and must then pay. Additionally, subarticle 24H extends this requirement to any counter-guarantor, meaning that the same preclusion rule applies if the counter-guarantor fails to comply with the proper rejection procedure. Once a notice of rejection is given, URDG 758 subarticle 24G allows the guarantor to return any paper document presented or dispose any electronic record as it sees fit, without incurring any further responsibility. This is in contrast with documentary letter of credit under UCP 600, where original shipping documents typically have commercial value, whereas in demand guarantee, the documents are normally copies and do not hold same value. When it comes to guarantees that are not subject to any rules, a well-drafted guarantee should ideally specify the number of days the guarantor has to examine a demand and decide to accept or reject it. But more often, there is uncertainty about the procedure for rejection, leaving the matter to be interpreted by the applicable law, which in many national legal systems requires that the guarantor does not purposefully delay sending the notice of rejection. Such delay, especially if the rejection reaches the beneficiary shortly before the expiry of the guarantee, may deprive the beneficiary of the reasonable opportunity to remedy discrepancies. And it must be considered an act of bad faith if the notice is not timely provided, or if the notice is not clearly indicate that the demand is being rejected, or it fails to list the discrepancies. Now, shifting focus to standby letter of credit under ISP98. ISP Rule 5 deals with rejection of the demand. However, one major challenge is the period allowed for issuer to check the presentation and give the notice of dishonor. ISP98 Rule 5.01 requires the notice of dishonor be given within a time that is not unreasonable. And while notice is given within 3 business days is generally deemed acceptable, notice given after 7 business days is considered unreasonable. Under ISP 98 Rule 5.03, failure by the issuer to give proper notice within the correct time period precludes rejection of the demand. To wrap up, rejection of non-complying demands under URDG758 requires careful attention to detail. Always ensure that rejection notices are correctly formatted, issued on time, and include all discrepancies. A mistake can lead to serious financial consequences. If you found this tutorial helpful, don't forget to like, subscribe, and hit the notification bell for more insights into trade finance and banking compliance. See you in the next video. Till then, take care. Bye bye.